the only criteria is that you were hurt at work. And that's typically the only threshold you have to clear as far as getting into the door of the Workers' Compensation Act.
This is the Trials Podcast, where we focus on the challenges the injured face and how we meet and deal with those challenges, especially in litigating catastrophic injury cases. I'm here with trial lawyer Forrest Taylor. Forrest, we really appreciate what you do for our clients, and in particular, litigating catastrophic injury cases. Today, I want to talk about the challenges the injured face, and in work injury cases, there's some specific issues, specific challenges. Could you talk with us about that today?
Sure. So if you're injured at work, your only avenue for a remedy is under Alabama's Workers' Compensation Act. And that has its own rules, its own regulations. And let me just get on my soapbox here. A lot of the Alabama Workers' Compensation Act is grossly outdated. And some of the rates of compensation have not changed since the 80s. And let me just give you a dramatic example. If you lost your leg in a work-related injury and you're limited to work comp, do you have an idea of what that recovery would be? It would be the most that you could get for losing a leg under Alabama's Workers' Compensation Act would be $44,000. And to make matters worse, you're not paid that in a lump sum. You're paid that over 200 weeks. And those are just some of the issues like that we deal with when we're working or dealing with workers' compensation injuries. So it's a very challenging environment that we work in because of the limitations under the Alabama Workers' Compensation Act. Now, a couple of other things to consider is that different injuries can impact people differently with respect to employability. For example, you may have somebody that does heavy labor and they have a back injury. That back injury might not be that substantial if that person was doing sedentary work, but it may substantially affect someone who does heavy labor, construction, things like that. So let me just give you an example of some of the injuries that we've dealt with in the past. For example, we had a painter drywall hanger who had a fall on the job, and he had a serious injury to his right shoulder, his right arm, and the doctor restricted him, permanent restrictions to lifting no more than 10 pounds with his right arm, and he could not do repetitive tasks with his right arm. And he had very limited education. And, if you first looked at that, you would think, well, this is not a real serious injury. But when you put that in context of what this guy did for a living, it was a very serious injury because there was no other profession that he could go to and make the type of money that he was making doing painting and drywall work. And we wound up trying that case, and fortunately we got a good result for him. But again, you have to take the injury, you have to take the guidelines under the Workers' Compensation Act, and it's like a puzzle that you're putting together in order to get your client compensation. Now, a couple of other things to keep in mind about Alabama Workers' Compensation Act is that your employer, controls who you go see for your medical treatment. And that's a big source of frustration for our clients because you can't pick your own doctor. you go to who the employer or their workers' compensation insurance company chooses. Many times we have clients, say, in Southeast Alabama that are sent to North Alabama for treatment. And again, that's very frustrating for our clients, but that's the rules that we have.
Forrest, let's anchor this discussion down with a few examples.
Okay.
You've touched on a case involving an injured worker that was a painter, drywall hanger. I think maybe had a complicated hand injury.
Right.
Could you talk us through the nuances of getting the case ready for trial? What were the issues? What were you hoping to accomplish in the trial? What did you have to prove, and how did you go about doing that?
The work comp carrier defended the case by a number of ways. They tried to minimize the injury. We had pretty good evidence from his treating physician. You know, as I mentioned, he had a weight restriction on his right arm, no repetitive movements, and he was in his mid-40s, and the workers' comp carrier, their side, really pushed, you know, he can be retrained. You know, there's a lot of things he can do. We defended that by saying, you know, he really had no formal education, very limited formal education. He was a smart guy, but just had very limited formal education. And we defended that by saying, look, retraining is not really an option. And there was really nothing that he could be retrained for that would put him at the same or roughly the same rate of compensation that he was making painting and doing drywall work. So that is one of the defenses that we typically see is, look, they can be retrained. There's plenty of other jobs in the market that he could do. And we were able to effectively counter those arguments by showing that, you know, based on his aptitude, his retraining was very difficult, and his age, because the older you get, typically the harder it is to retrain. And, you know, the other thing that we're able to attack is the availability of some of the jobs that they suggested that he could do. And when you scratch beneath the surface, there just wasn't a lot of those jobs available in this area that they suggested that he could do. You know, for example, you know, they said he could work at a call center. And, you know, when you look at the availability of those jobs, they were just very limited. And so that's how we attacked their defenses to his claim. So, you know, and we were able to effectively do that. And, you know, and what really helped was having good doctors, you know, records that supported our case, and also a strong expert, a strong vocational expert.
And so in Alabama, if it's just strictly a workers' compensation case, and it goes to trial, or workers' compensation claim that goes to trial, is a bench trial in front of a judge.
Right.
So what was the judge's decision? Where you know, what kind of difference did setting this case up, proving the injury, proving his and we're saying painter, drywall hanger, but I'm assuming this is a man that had done this kind of work for years.
Right.
Professional
Started
painter,
when he was a teenager.
Professional drywall hanger. This is his livelihood.
Right.
His
right.
This is how he takes care of his family.
Right.
So you're having to prove the injury,
right,
and the impact of that injury, and the potential opportunities.
Right.
So how does that work in front of the judge? And what difference did the judge, you know, essentially you proved, and what kind of difference did that make in the case?
Right. So you bring up some important questions. And let me say that under the Alabama Workers' Comp Act, being found 99% disabled versus 100% disabled as far as your ability to return to substantial gainful employment is huge monetarily speaking. It is a that 1% makes a big difference. And that is one thing that is difficult when you're on the plaintiff, when you're on the injured worker side, is again, if your client was found 99% disabled, the amount of compensation that that worker is entitled to is going to be minuscule compared to a finding of 100% disability. So
and that's what you were pushing for.
That's what we were pushing for. That's right. And the other thing to keep in mind is that to be 100% disabled under the Alabama Workers' Compensation Act does not mean that you're helpless. Okay, and I think this is an important thing for people to keep in mind is the definition of a permanent total disability under the Alabama Workers' Compensation Act is your inability to return to substantial gainful employment that would compensate you along the lines that you've been accustomed to. Okay, so that's what we're talking about when we refer to like a 100% disability. Again, the person is not bedridden. It's just they cannot return to substantial gainful employment. And a couple of other things to keep in mind. We've had a lot of situations where the injuries, for example, back injuries, where somebody is able to maybe work 2 or 3 days a week, but that's still not enough to qualify as substantial gainful employment. So it is important, and it is important to have the evidence marshaled to present to the court to prove the disability, to prove the impairment. And I think the other thing that's also important is, sometimes judges may not have tried many workers' compensation cases. We always try to present a trial brief that outlines the law, the standards applicable, and how our evidence meets those standards. And so, typically that, and again, you make an important point, is in Alabama, the cases are tried before a judge. There's no jury. The other thing to keep in mind is if it's a workers' comp case, you don't get an award for pain and suffering. You don't get an award for disfigurement. It's solely based on your ability to earn a wage.
And to close out the case involving your professional painter drywall hanger with the hand injury, the defense was arguing that that 1%, that he was not, that it wasn't a permanent total disability, and they were trying to prove that, for example, it wasn't a permanent total disability, and that he could go to work, for example, in a call center.
Right.
So specifically, what did you do to address that, and how did the judge ultimately rule?
We addressed that, for example, with a call center, that the availability of those jobs were so low that it was not reasonable for him to even pursue that. There were just so few jobs out there. The other thing, and we see this in a lot of cases, is, it could be a security guard. Well, the problem with being a security guard is that, he could not, I think his weight restrictions with his right hand was 10 pounds, and that was his dominant arm. A lot of times, security guards, have to lift things, move things, and there is some physicality associated with those professions. And that's how we addressed those attacks. Either those jobs really weren't available in this area, and, if they were, his restrictions would actually preclude him from getting those jobs. And so that's how we address those.
And again, ultimately, the judge ruled that it was a permanent total disability.
That's correct. And, the other thing, and I think I mentioned earlier on, is that, in addition to the compensation that you get, then the employer is responsible for the medical treatment for the rest of that employee's life for those injuries, for those work injuries.
You've touched on some general principles of law,
right,
as it applies to Alabama workers' compensation cases. Typically, in say a tort claim or a negligence, reckless, wanton conduct, we have to prove liability. We have to prove fault.
Right.
And in workers' comp cases, that's typically not an issue.
That's right. And that brings up a good point, because, and this is an oversimplification, but the only criteria is that you were hurt at work. Okay. That, again, that's an oversimplification, but you don't have to prove fault. It could be just an accident that happened at work, and that's typically the only threshold you have to clear as far as getting into the door of the Workers' Compensation Act.
And often that injury at work while working in a line and scope,
right,
the injury at work triggers workers' compensation benefits.
Right.
And one of the biggest challenges that we see and that we've dealt with over the years is I think sometimes that can lull an injured worker into a false sense of security.
Right.
They're taking care of my medical. They're taking care of my weekly wage benefits. I'm getting the benefits I'm entitled to. And I think sometimes you layer on that a catastrophic injury. This is how I take care of my family. This is how we pay the mortgage. And sometimes, even though it's not a fault-based thing, but we hear operator error, or the injured worker is blamed for causing the injury. And in so many of the work injury cases, you have machinery, equipment, other factors that could potentially get a case outside.
Right.
So on the one hand, the benefits have started. So a family oftentimes is not thinking about, they're thinking about, and rightfully so, getting the medical treatment, but they're not thinking about outside claims. So I would like for you to talk about, how that works. One of the things that we do is evaluate a case to make sure that anybody that's responsible is held accountable.
Right.
And
yeah, and that's another good point that you make, because let's assume that you're at work and you have a piece of machinery, and that piece of machinery has a defect in it, and you're injured because of that defect. You've got two potential claims. You've got your work comp claim, and like you said, that's sort of automatic. You may have a claim against the manufacturer of that piece of equipment. And that's why we encourage people that if you're hurt at work, even if, your medicals are being taken care of, you're getting disability, you still need to talk to an attorney, especially if you think that there's somebody else that could be responsible, because a product manufacturer does not have the protections of the Alabama Workers' Compensation Act. That is a separate claim. The advantage of that separate claim is that you can recover for things that you could never recover for under the Workers' Compensation Act. For example, pain and suffering, disfigurement. those things. You can recover from that third party, and those are not available under the Workers' Compensation Act. So, that is a reason that if you are hurt at work and you have a serious injury, it's always good to consult with an attorney. And because an attorney may recognize a third-party claim out there that could dramatically make a difference in what that injured worker recovers.
And Force, one of the things that we've seen so often, which demonstrates a big challenge in injury cases, and specifically work injury cases, the company, the employer, controls the work environment. They control the equipment.
Right.
They oftentimes have control or some control over who's conducting an internal investigation. And something that kind of a theme that we've seen play out in these cases, that injured worker gets blamed for causing the injury. And in the most extreme cases, most unfortunate, tragic, if there's a death involved.
Right.
We've seen cases where, again, that worker is blamed. So it's like the last thing a family wants to do is continue to, it could be like throwing salt on a wound, but they really don't know what happened.
Like you mentioned, the employer typically controls the environment, controls access to that environment, and we have had to file legal actions to get in there to do the investigation. And a lot of times what we find is a lot different than what the employer was initially representing. And so, but again, to get that information, a lot of times we may have to initiate a legal proceeding.
And Force, in a sense, aren't you, presenting that a little gently? I mean, haven't you, I know you've been involved, we've been involved in work injury cases, right, where not only is what we find different, there's actually a concerted effort to shift blame, whether it's an inspection on a piece of equipment that's pencil whipped that should not be in service. I mean, we've had cases, for example, a welder goes in to do maintenance, that's called out to a plant to do maintenance and repair, and is a welder, mm-hmm, shows up to work on a piece of machinery, has no access to lockout, tag out, control rooms, anything like that, goes in to do his work and is crushed by a door. Right. And the family's told, we're sorry, we'll pay for the funeral, mm-hmm, but it was his fault.
Right.
But the reality, there was no lockout, tag out.
Right.
He had no access to any of the machinery, any of the equipment. He just showed up to do some maintenance on a piece of equipment. A less extreme case, we saw a man that, had his hand crushed in an industrial door, mm-hmm, that had been out of service for weeks, if not months. And again, the representation that the company line sometimes is again, an effort to shift blame, shift right, liability, shift responsibility. And when a family faces that, again, what I have seen in some cases is, again, I know I keep saying the same thing over and over, but it's a point that I want to drive home to anybody that's in this situation,
right,
that is listening to this. It can often be the legacy of that deceased worker. Mm-hmm. For a family to think he was responsible for this and So the last thing we want to do is pursue only to find out. But again, we have found that's just not the case, that it's actually the company, it's actually, somebody else is responsible, and they're just doing, going about their day, doing their work. Forrest, I appreciate you being here today. I'm really excited and looking forward to your discussion with vocational experts, Dr. Mike and Dr. Matt.
Now, one important thing is that if you have an injury, a permanent injury, how does that affect somebody's ability to make a living? How do we prove that? We can look at the medical records. We can take the doctor's deposition. But many times we have to rely on vocational experts. A vocational expert is a person trained to review medical records, look at the injury, and then look at the job market. And many times they'll come up with either this person is unable to return to substantial gainful employment, or they'll come up with a percentage like, this person, in this job market, because of this injury, is eliminated from 50% of the job market. So a vocational expert is very critical especially in work comp situations, and they can also be helpful just in your run-of-the-mill personal injury cases where somebody's injury has affected their employability. And we're very lucky today to have two of the best experts that I've worked with, Dr. Mike McClanahan and his son, Dr. Matt McClanahan, and they're vocational experts. They're headquartered in Auburn, but they work all over the Southeast, and we're very fortunate to have them on the program today.
I am Michael McClanahan. I live in Auburn, God's country, and I have been a vocational expert for 35 or 40 years now. I have a PhD from Auburn University, a master's from the University of Georgia, and I have worked as a vocational expert with Social Security Administration for more than 30 years. I've testified in more than 25,000 Social Security disability cases and testified in several hundred personal injury cases, which is a topic here today.
Right.
I'm well published, and have been all over kind of mostly the southeastern part of the United States as an expert witness.
And Matt, tell us a little bit about your background.
Sure. I've been in the field of vocational rehabilitation for about 15 years now. I began as a state federal vocational rehabilitation counselor for Alabama, where I also served 4 different high schools. And then I transitioned after getting my PhD into practice with my dad, the elder Dr. McClanahan.
Right.
And so I do workers' comp cases, personal injury cases, and I'm also an vocational expert in Social Security hearings.
So let's talk about a little bit, let's say, workers' comp. Tell us what your role is. Let's say, Dr. Mike, how do you approach a workers' comp case typically?
It varies by state, actually.
Right.
In Alabama, the emphasis is on a vocational disability rating. The similarity, there actually is a similarity that gets overlooked in our field about how personal injury and worker comp cases actually coincide from a vocational standpoint, because from a vocational expert standpoint, in Alabama worker comp, we're supposed to testify as to the degree to which an injury affects a person's ability to work and earn wages in the future. Well, the ability to work and earn wages in the future is generally the main issue in personal injury cases too.
Right.
So there's a great deal of overlap there.
So what are some of the things that you look at when you're evaluating a vocational disability? I assume, for example, medical records, but what are some of the other things that you rely on?
In both personal injury and worker comp, we would look at what their past earnings were, what their capacity to earn wages are, and then ultimately the question is, how does that particular injury affect the person's ability to work and earn wages in the future? I think the sort of the bigger difference between, theoretically anyway, worker comp and personal injury from a vocational expert standpoint is that in personal injury cases, we're looking at, or most interested in, the capacity to earn wages. In worker compensation, we're looking at sameness. We're looking at how close can they get in the future to what they were earning at time of injury.
Right. Matt, tell us, say, for example, what type of injuries do you deal with typically, and how do those affect employability? And I'm thinking about somebody that does physical labor versus, say, somebody that sits at a computer. Can you elaborate on that?
Right, absolutely. Yes, we really address the whole spectrum of acquired injuries, whether the person was working in a sedentary position or a heavy to very heavy position. And I guess what I've found in both, especially in workers' comp cases, is that a lot of these individuals that we see are doing hard manual labor, and they do use their body, primarily to earn wages, and that can put them, make them susceptible to various physical injuries. With personal injury cases, I'd say the majority of them involve motor vehicle collisions.
Correct.
And the type of the physical impairments are typically anything to do, with the spine. We end up coming across a lot of individuals who have head injuries, but we're not diagnosed with it. So we recommend neuropsychological evaluations quite often. But yeah, a lot of physical injuries to the extremities mainly. And just to piggyback off of what the senior variant McClanahan, my dad, said earlier, is we don't just look at, medical records and earnings records and things like that, but we also like to collect all sorts of different aspects of information from the client's background. And we do that through a pretty extensive vocational interview before we do testing, and then send off the different forms to receive medical records, education records, things like that.
Right. So tell us a little bit more. You piqued my interest on the head injury and like traumatic brain injuries. What are some of the deficits that you typically see with those types of injuries?
My dad can also address this, but usually what we see, whether or not the person has a loss of consciousness, is almost immaterial to whether or not they end up having an undiagnosed traumatic brain injury. But what we look at we have a checklist of questions that we ask regarding, are there any changes to your senses? Has your taste changed since the injury? That's an indicator. Has your vision changed? Do you have tinnitus in your ears? Do you have ringing in your ears? And a lot of times, other issues include things like short-term memory, expressive aphasia, or word recall. And it's fascinating, truly, how often a brain injury goes undiagnosed, because after someone is in, say, a motor vehicle collision, typically they go to the hospital and they're just checking for structural damage to the skeleton or the musculoskeletal portion of the body.
Yeah, that's interesting, because we've, in our practice, we do mostly personal injury, and we see that a lot where somebody has had a head injury, but it's not addressed in the ER, and it's only later on where they get to their primary care physician, and they continue to have these symptoms. But it's interesting that you bring that up, because we see that quite a bit.
We really appreciate you listening and subscribing to the Trials Podcast. Please be sure to join us as we continue our conversation with Dr. Mike and Dr. Matt.